Deputy McLeish.
Can you hear me now?
Yes, we're gonna start with a Zoom from Wood County on a defendant that's over there, and then we'll be live with y'all.
Perfect. Do we know if probation is coming today?
As far as I know, Karen's coming.
Okay, thank you.
Good afternoon, Mr. Scott. Can you see and hear me okay?
Yes, Your Honor. Thank you. How are you?
Good, doing fine. Mr. VZ, are you able to unmute that device? Let's give Mr. VZ a chance here to get staff to help him. Thank you, sir. Mr. VZ, can you see and hear me okay?
Yes, sir.
All right, this is cause number CR 19-210, CR 19. I believe that we're set today because Mr. VZ, you have filed a motion to terminate court-appointed counsel, Mr. Scott. Is that correct?
Yes, sir.
And Mr. Scott, have you had an opportunity to review Mr. VZ's motion?
I didn't see a motion. I did see a letter he had sent to the court.
Well.
Maybe that's what, and I think that was the reason why this got said. I don't know if an actual motion was filed, but yes, I did see his letter.
I think you're correct in that. I think I'm just terminating a motion because he is represented. So would you like to address that letter at all, Mr. Scott?
Your Honor, if if he feels it's in his best interest for me not to be his lawyer, I certainly don't have any objection to the court appointing a new attorney. However, his reasonings for, he stated that that I was not prepared or hadn't prepared for his case, and that couldn't be further from the truth. I've spent quite a bit of time preparing for this case, so that's not true. And I think his other concern was my performance at his other issue was my performance at Vordaer, which I don't know. I guess that's his opinion. Wasn't up to his high standards, I guess. But I'm going to do the best job I can for Mr. VZ. I don't have any personal issue with him. I get along with him fairly well, I think. So, but it's up to the court, Your Honor.
Thank you, Mr. Scott. Go ahead, Mr. VZ.
Well, I mean, I've asked him to do several things in 3 years and 8 months. He hasn't done one of them. He's always given me his opinion. I never really asked for his opinion. I just asked him, if I continue now with him, it'd be the classic definition of insanity, expecting different results, doing the same thing over and over again. So, I mean, he showed me how he's going to represent me at the trial, which wasn't very good at all. You had to save him, which you didn't have to, but I'm glad you did. But I mean, that's where I stand at this point.
And tell me, Mr. VZ, what is it that you've asked Mr. Scott to do?
I've asked him about pre-trial, during the pre-trial hearing, I asked him to file motions 3 years ago and he never filed any of them.
And what motions were those?
Like I asked him to file a motion to suppress evidence over 3 years ago. I've asked, during the Vordaer, whenever they amended I objected to the amendment that they did against the deal. You're supposed to have that in writing within 10 days of Vordaer, which he never did that. And it's just several things. That's just the main things.
Well, let's do this. Let's talk about each and everything because this is your opportunity to be heard. And I'm going to make a decision. And I don't want you to later say that you were not given an opportunity to air all of your complaints against Mr. Scott. And then I've got to judge those on a legal basis to see if Mr. Scott's performance is deficient to the level that it would rise to either ineffective assistance of counsel or that there's no longer a sufficient relationship between you and Mr. Scott that would guarantee good communications between attorney or client. So list everything that it is that you believe Mr. Scott has done that is improper.
Well, and then whenever I was moved to Henderson County to prepare for trial, we never prepared for trial. He keeps trying to cram this plea bargain down my throat. And he hasn't shown me all my discovery. I still haven't even seen my indictment from whenever I got indicted over 3 years ago. He never shows me in my paperwork. It's always his opinion, and it's always one sided. He's never, that's just point blank with it. It's either his way or it's no way. It's not my high standards. That's just general practice. Since he's over 20 years experience of doing this, it's just he's simply not doing what I asked him to do. Point
So,
blank.
so you said you said he hasn't shown you the indictment, and
No.
he hasn't prepared for trial. What else?
No, I mean, not in my eyes, he hasn't, no.
Okay, and tell me what in your eyes would contemplate preparing for trial that would satisfy you?
I mean, during that pre-trial was a joke. I did it via Zoom. And then you're supposed to have, which that's the only thing that I seen he did right, was leave it open with the sitting judge that sat in for you. He said, if later on I feel I need to file motion, then leave that open. That's the only thing that I remember him, actually doing in 3 years and 8 months worth doing. I mean, there's so much more he could do to just sit back and just, oh, well, this is it. I mean.
Well, tell me what that is. Tell me what it is that Mr. Scott would be able to do and you would expect him to do.
What I asked him to do.
And what is that? We all don't know what that is. I'm asking you
To file motions, the motions that I've asked him to file.
Okay, and what motions are those that you've asked him to file that he hasn't?
Like whenever we was going to trial, I had the option, the forensic tech. I noticed that in the Texas session law, you can have a forensic tech, just like we're doing here by Zoom. I wanted one of them to discuss the DNA facts. And then I asked for the motion, to suppress all the evidence. Then I wanted a fast and speedy trial before the pandemic ever hit. And that was right after I got the PR bonds. And then the motion to object to the amended indictment where they amended 5 to 99 years whenever it was 3 years, 5.5 months before I even knew that it was 5 to 99 years. Whenever I went to Henderson County, when he finally told me, oh, well, they just, amended the deal, now it's 5 to 99 years. Whenever in your courtroom, whenever I got arraigned in 2019, it was on a second-degree felony, aggravated assault, and you PR bonded me on a second-degree felony, aggravated assault. So for 3.5 years, that's what I'm thinking I'm going to court on. And then all of a sudden, whenever I get over there and we're preparing for this trial, it's 5 to 99. So, I mean, you could have told me that 3.5 years ago, and we could have did a whole nother route, and I could have studied this a little different. But now it's just all of a sudden, here it is, this is what we're going to just take this. And I can't do that.
What else? What are the other motions?
I can't think of them. I bet I have them written down back in the dorm.
Why didn't you bring those with you? You knew we were
I'm on the set right now. I got to fight.
Okay.
And I don't have all my property. So I won't get out to the first.
Okay. All right, Mr. Scott, do you want to respond to any of those allegations?
Well, I think what Mr. Veazey is referring to as far as the indictment, the range of punishment, the heading of the indictment does say, I'm not looking at it, but I've looked at it enough. It says, I believe it just says aggravated assault, and I think it even indicates it's a second-degree felony. But I advised Mr. Veazey well before trial that it has all the elements of the offense of aggravated assault against public servant, which is a first-degree felony. And I've even sent him well in advance of trial, in writing, the range of punishment of being up to life in prison. So he was and I think I sent that letter in October, and I told him in person before that. I just kind of got nervous about what he was saying, so I decided I better put in writing. So in October, I sent him a letter that's got that range of punishment. So that was, and before that, I'd had that conversation with him when we were still able to plead the case. So I just wanted to make sure he understood what the range of punishment was. So, I've explained that to him, but he was under the impression that because the indictment says second-degree felony, that he couldn't be charged. And I told him I researched that issue, and that the heading of the indictment isn't actually what's legally required as far as an indictment is the body and paragraphs of the indictment. Whatever the heading says, the case law said that doesn't apply. It's the actual language and the elements of the indictment. And I tried my best to explain that to Mr. Veazey, that those all are the elements of first-degree felony. So that's what the jury was going to be tried on. So I did my best to explain that to him, and I told him what the range of punishment was on that. As far as the motion to suppress, he talks about the DNA. The DNA report I got doesn't say that Mr. Veazey's DNA was on the firearm. So I didn't, the state can correct me if I'm wrong, but it doesn't say that his DNA is on that firearm. So I don't know why I would want to retest that. It sounds like it could only come back worse. If we've already got DNA saying it's, not him on the firearm. So I didn't see any reason to challenge that. As far as an motion to suppress, he didn't give any custodial Mirandized interviews, or they didn't, come to his house and take any evidence or any of the typical things that, I would normally file a motion to suppress over. It doesn't, none of this evidence that, that I've seen would fall under that. And furthermore, I didn't see any illegal police conduct that would make that be a good faith motion, any good faith motion to suppress to be filed. I don't know, maybe I'm forgetting one of the issues he's raised, but that's what I can recall him bringing up.
All right, thank you, Mr. Scott. Mr. Veazey, do you want to hire your own attorney? You always have that right. Mr. Scott is here because he was on the court appointment list at the time that you were indicted, and the court found you to be indigent, and the court appointed Mr. Scott. And you always have the right to retain your own attorney if you want to do so. Are you gonna hire your own attorney?
No, I can't do that. I've been here almost 4 years now, Mr. Martin. I mean, I'm still entity.
Okay, well, I just want to make sure. Sometimes you have family members that are able to help, so I don't know your circumstances. So
I mean, I'm just now getting okay with them, but I don't know if we're gonna hire one or not.
okay, well, what I'm hearing then, based on your complaints about Mr. Scott, and I will let the record reflect that at the voir dire, the jury selection process.
He referenced himself as a state and then hurried up and cleared that up, said he was defense. That made me nervous then, while he's sitting there talking about he was nervous.
I understand.
Confused and made all the potential jurors mad, and that's whenever you had to step in and say something. I mean, that was embarrassing.
Well, there's, unfortunately, I've called myself the state several times as I'm sitting here as a judge, so those things happen.
Well,
It doesn't.
I consider you part of the state.
I understand, but I am not the state. So I'm just saying that sometimes mistakes are made, and they're not fatal mistakes, and they don't rise to the level for an attorney to be removed from a case. And the whole jury selection process, wherein the mistakes were made, were not they were not because of Mr. Scott, and they were not because of the state, and they were not because of the court. It was because the clerks and their processes didn't.
I don't hold you or the state or Mr. Scott. I don't hold none of y'all. We could have went ahead with that, and it would have been what it was. I don't have a grudge against any of you. You know what I mean? It's just the whole situation that I'm in right now. I'm just trying to get past it.
Understand. Well, I just want to explain to you, and I want the record to reflect that I made the decision to declare a mistrial at the time of jury selection because the jury selection process was not up to what I thought was fair with the notions of justice for you and for the state and for a clear appellate record. So, but I want the record to be clear that
it was you that declared the mistrial on your own.
Right, but there was nothing. Right, but there was nothing that Mr. Scott did or didn't do that caused that. Okay,
Right. I mean, he told me that he could have asked for one, but he always seems to know what your answer is gonna be. That's another thing I can't, bothers me about him. He always seems to know what your answer is gonna be about everything. That's why he don't want to do anything. That's
well,
another thing I forgot about.
I can understand that perspective, but I can also tell you that a lot of times that's an indication of a good attorney because they know how judges are going to rule. They study patterns, they study, consistencies, inconsistencies. So just because he has an opinion on which way he thinks the court may or may not rule, I think if he didn't at least give you his opinion on that, then that might indicate that he's unsure or inexperienced. And I know I can speak from personal experience on Mr. Scott's behalf that I've tried cases against Mr. Scott, and he's a very good attorney. We've tried a capital murder against each other where I was on the state and he was on the defense, and he did a great job and always held me to my burden throughout the entire trial. So I don't in any respect doubt Mr. Scott's ability to provide you with a zealous defense, but
I didn't either until his opening statement, whenever he got confused and confused everybody, that's whenever I got worried. I never had a problem up to that point. That's the only real issue I had.
I understand. So what I'm going to do, Mr. VZ, is I'm going to deny your request to remove Mr. Scott as your attorney. And I'm going to ask that you and Mr. Scott continue to try to work together so that y'all can resolve the matter that you have. If there's a communication issue still persists, and I'm sure Mr. Scott will bring that to my attention. If not, you can do so. Okay. All right. So Mr. Scott's told me that he doesn't mind continuing representing you. He hasn't said to the court that he feels that he can, or that y'all don't have good attorney-client communication. So at this point, for the reasons that you stated, I don't find those to be valid legal reasons to remove Mr. Scott at this time. And Mr. Scott's willing to continue in his capacity as a court-appointed indigent defense counsel. Now, if a time ever arises, Mr. VZ, wherein you can hire your own attorney, then you do so and you notify the court, and that new attorney can file a motion to substitute counsel, and the court can discharge Mr. Scott at that time. Until that time arrives, then I've got to ensure that you are represented by adequate defense counsel, and I find Mr. Scott to be more than that at this time.
Yes, sir.
Okay. All right. Thank you, Mr. VZ. Thank you, Mr. Scott. We'll be adjourned in this hearing.
Your Honor, may I bring up an issue? I
Yes,
just
go
want to update the court. I had filed a motion for continuance on that January 30th setting that the court set due to a CPS trial. And I just want to let the court know that we mediated that and that case is resolved. And so I no longer have that conflict for the January 30th setting.
Okay. Thank you, Mr. Scott. I'm not sure if I had ruled on that motion yet.
I don't think you had yet, Your Honor. Because I had mentioned, I think to Patty, that I was waiting for this mediation to hopefully resolve that case. So.
Yeah, I believe that is correct. So, okay, well, so if the state could be ready on January 30th, then I had to look at my special settings.
My understanding, Your Honor, is that there is another case before Mr. VZ. He is the number 2 case on that date. Obviously, as we approach, we will see which case goes on that date, but I have no doubt that we will work to be ready for either or both cases.
All right, thank you. All right, thank you, Mr. VZ. Thank you, Mr. Scott.
Thank you, Your Honor.
You're welcome. All right, who do we have ready at the Van Zandt County Justice Center?
Mr. Cunningham, Your Honor.
All right, Mr. Cunningham, if you'll step on up. All right, these are cause numbers CR 22-212, F19-7, State versus Jeremy Quinn Cunningham. And I believe that this is a plea today, Ms. Lee, is that correct?
Yes, it is, Your Honor.
All right, and I had a copy of the plea agreement earlier, but I think I had Patty send that out to the jail, so I don't know the terms. Can you just tell me the terms at this time, Ms. Lee?
Yes, Your Honor. So he's pleading guilty to burglary of a building, and it's a state jail felony. The terms are 7 months TDCJ, no fine, restitution of $1,135, $290 in court costs, and $35 in reimbursement fees, Your Honor.
Does he
and-
have- Go ahead.
In 12 days jail credit.
Yeah, repeat that for me. I didn't quite catch that.
212 days of jail credit.
All right, 212 days, 212.
Yes, Your Honor.
Okay, and is the possession of controlled substance being pled to or dismissed under 1245 or just straight dismissed?
My understanding is it's being straight dismissed, because that was a motion to revoke, and it has been withdrawn, Your Honor.
Is that correct, Mr. Woodwhite?
I believe that's correct, Your Honor. Let me check and make sure, but it's being resolved at this time. Let me check and make sure exactly how.
All right, while he's doing that, Mr. Cunningham, we're going to go ahead and swear you in. If you'll take your right hand, raise it, please. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Thank you, sir. You can lower your hand. Your name is Jeremy Quinn Cunningham. Is that correct? And Mr. Cunningham, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
And have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Ms. Shunda Lee. Are you pleased with her representation of you?
Yes, sir.
Do you feel like you've had enough time to talk with her about both of your cases and that you've had all your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read over and signed today that you do not understand?
No, sir.
And you heard Ms. Lee read the plea agreement to the court. Is that your understanding of the plea agreement today?
Yes, sir.
Ms. Lee, do you believe Mr. Cunningham to be competent?
Yes, Your Honor.
And have you explained to him his rights as they pertain to each case in this plea agreement?
Yes, Your Honor.
And do you believe he understands his rights and the important waivers of those rights he's making herein?
Yes, Your Honor.
Mr. Woodwhite, were you able to determine F-19-7?
Yes, Judge, that's actually, as you can tell by the cause number, is actually downstairs. It was withdrawn and terminated by Judge Winters about a month and a half ago. So that has been resolved. I'm not sure why it's still on our docket.
Okay. And you said that was a probation case?
It was a probation, it was a motion to revoke. So he has been previously convicted on that. He was on probation. We are withdrawing. And he was withdrawn and terminated. I believe we reached this agreement some time ago, but he was still in Smith County's custody at that time. So it was getting that off the docket.
So Judge Winters has already ruled on the motion to withdraw and terminate?
On the 24th day of August, yes, Judge.
Okay, good. All right, so we won't be addressing that case today at all. All
That's
right.
correct.
All right, Mr. Cunningham, you are charged with the state jail felony offense of burglary of a building. Range of punishment for that offense is not less than 6 months in prison, not more than 2 years in prison, and a fine not to exceed $10,000. Court finds that the proposed plea agreement would legally fit within that range of punishment. Mr. Cunningham, how do you plead to burglary of a building, a state jail felony?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty today?
No, sir.
All right, the court will accept the defendant's plea of guilt. Ms. Lee, any objection to the state's evidence?
No objection, Your Honor.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we would rest and close at this time.
Anything further from the defense?
Rest and close, Your Honor.
All right, Mr. Woodwhite, can you give me the facts to support the plea?
Yes, Your Honor. The precinct 4 constable is, it's reported to them that someone has broken into a self-storage in Van, Texas. The victim reports that shadow boxes of Indian memorabilia have been stolen. A witness states that the defendant tried to sell them that property in exchange for some other property. The defendant told the witness that he has had the items a long time. the constable gets a warrant for defendant, and he confesses to breaking into the self-storage unit.
Thank you, Mr. Lee. Any objection? Ms. Lee?
No objection, Your Honor.
All right, then based on the evidence presented to the court will find that there is sufficient evidence to convict Mr. Cunningham. The court will follow the plea agreement reached between the state and the defense. Court hereby convicts Jeremy Quinn Cunningham of burglary of a building, a state jail felony, assesses his punishment at 7 months confinement in the state jail division of TDC, orders him to pay restitution of $1,135, $290 court cost, $35 restitution. I'm sorry, $35 reimbursement, and the court will award Mr. Cunningham 212 days credit towards this sentence for the time that he has spent in jail on this cause. Mr. Cunningham, once you are released from TDC, you need to report to the courthouse to make arrangements to discharge the restitution and court costs and other fees that you owe. You understand?
Yes, sir, Your Honor.
All right, and failure to do so will result in the court issuing a warrant for your arrest. All right, Mr. Cunningham, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Have you step over with the deputy to be fingerprinted.
May I be excused, Your Honor?
Yes, thank you, Ms. Lee. All right, Mr. Stevens, who are you ready on?
Nicole, Your Honor. Come on, Nicole.
All right, this is State of Texas versus Nicole Lynn Pentler, CR 22-283 and CR 22-284, set for pretrial. Go ahead, Mr. Stevens.
Judge, we have no formal pretrial matters to take up, and we're going to ask it to go to docket.
All right, there being no contested pretrials, court sets this matter for docket call. We'll set this in January. Are you available on January 5th or 24th, Mr. Stevens?
Yes, sir, Judge, the 5th.
The 5th? All right, court sets Ms. Pentler for docket call January 5th. That will be at 1:30 if she's in custody, 9 a.m. if she's not. And Mr. Stevens, of course, you know that I'll be looking for some kind of announcement on the 5th as to whether Ms. Pentler is reaching a plea agreement or requesting a trial.
Yes, sir.
All right. Is that all you have, Mr. Stevens?
Judge,
Thank you, sir. You can Merry Christmas.
thank you, Judge. Thank you.
Mr. Adams, are you ready?
Ready, Your Honor.
All right. Who do you want to go on first, sir?
Mr. McFarland, nearest.
Shannon Dale McFarland, CR 2235. All right, Mr. McFarland, if you'll raise your right hand, sir, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir. You can lower your hand, just make sure you speak up loudly and clearly so that I can hear you, my court reporter can take down what you have to say. Mr. McFarland, are you a United States citizen who reads, writes, and speaks English?
Yes,
And have you ever been diagnosed with a mental condition?
yes.
Can you tell me about that?
Post-traumatic stress disorder.
Okay. Are you currently on medication or undergoing treatment for that?
I'm not.
Do you feel like you have a rational understanding of the proceedings as they are going on against you today?
Yes, sir, I do.
In this case, you are represented by your attorney, Mr. Mitch Adams. Are you pleased with Mr. Adams as your attorney?
Yes,
Do you feel like you've had enough time to talk with him about your case and to the point where you've had all your legal questions answered?
yes.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, sir.
Mr. Adams, do you believe Mr. McFarland to be competent today?
Yes, Your Honor, I believe Mr. McFarland is legally, mentally competent.
All right, and have you explained to him his rights as they pertain to this case?
Yes, Your Honor, I have.
And do you believe he understands them and the waivers of any rights that he's making today?
I believe he does understand, Your Honor.
All right, is the original indictment indecency with a child by sexual contact, or is that a different charge?
Your Honor, I believe the original indictment was for continuous sexual abuse of a child.
Okay. All right, so Mr. McFarland, you were originally indicted with that offense, but I see here that the plea agreement in this case is that you would plead guilty to a lesser included offense of indecency with a child by sexual contact, a second degree felony, with the state recommending that your punishment be assessed at 10 years confinement in prison, but the state's recommending to the court that the court place you on community supervision, order you to pay a fine and court costs and reimbursement fees. Is that your understanding of the plea agreement, Mr. McFarland?
Yes, sir.
All right, and the range of punishment for a second degree felony, if convicted and sentenced, is not less than 2 years in prison and not more than 20 years in prison. And the court finds that this plea agreement would fit legally within that range of punishment. So, Mr. McFarland, at this time, I would ask you, how do you plead to indecency with a child by sexual contact?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Did you say yes, sir, or no, sir?
Yes, sir.
You're saying yes, sir, but you're shaking your head no.
Yes, sir.
Okay. Well, you can understand my confusion. If you're saying yes, sir, that's very confusing to me.
Thank you, sir.
Okay. And Mr. Adams, so the court's going to accept the defendant's plea of guilt at this time. Mr. Adams, is there any objection to the state's evidence?
No objection, it's marked it off.
All right, state's evidence is admitted and the court takes judicial notice of the defendant's judicial confession at this time. State, can you tell me if there's anything further and then tell me about victim compliance?
Yes, Your Honor. State is in compliance with victim notification. However, we have nothing on file to present to the court at this time with that regard. Your Honor, after we finish this plea, the state is going to be offering a agreed mandatory protective order for the lifetime of the alleged victim in this case. It was a family member of Mr. McFarland. So we're taking care of that, but no additional documentation to present to the court other than that.
All right, thank you. Anything further from the defense, Mr. Adams?
Your Honor, we rest.
All right, can the state give me the evidence to support the plea?
Yes, Your Honor. In June of 2021, a mom came to the Van Zandt County Sheriff's Office to report that her 7-year-old daughter had made an outcry of abuse by her by her uncle. They conducted a forensic interview at the Child Advocacy Center in which she outcried that Uncle Shannon and her were laying on the couch when he touched her no-no spot inside of her pants and under her underwear.
Okay. Any objections, Mr. Adams?
No, Your Honor.
Okay. All right, and this is the recommendation of the DA's office to place Mr. McFarland on community supervision for this offense, correct?
Yes, Your Honor.
Okay. All right, then based on the evidence and the recommendation of the state, the court will follow the plea agreement in this case. Court hereby convicts Shannon Dale McFarland of indecency with a child by sexual contact. The court assesses his punishment at 10 years 10 years confinement in the Texas Department of Criminal Justice. The court will suspend that sentence based on the recommendation of the state, will place Mr. McFarland on 5 years community supervision, order him to pay a $2,500 fine, $290 court cost, $1,270 in reimbursement fees. The court will find that the defendant is required to register as a sex offender in accordance with Chapter 62 of the Texas Code of Criminal Procedure. Court will find that the age of the victim at the time of the offense was 7 years old. Mr. McFarland, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you step over with the deputy to be fingerprinted, and then the probation officers will give you more information about what's next for you.
I was supposed to be getting your paper printed out.
I'll tell you.
All right, Mr. Adams, are you ready on Josie Bohannon?
Yes, sir.
All right, Josie Cheyenne Bohannon, CR 22-2. I read. All right, Miss Bohannon is set for pretrial. Mr. Adams, go ahead.
Dr. Last time we were here, Your Honor, excuse me, I had an issue in that I had not received a copy of the video footage in this case. Since then, I've received a portion of it. However, along with that, the state and I believe have reached terms for a plea agreement for Ms. Bohannon. We did that today. Therefore, we don't have the paperwork ready to go, but we are available on January 5 to go ahead with that and make it happen.
All right, and will that be a plea for time or probation?
Time.
Time, okay. All right, then the court will find that there are no contested pretrial motions, and the court will set this for plea on January 5th at 1:30. Is that all you have, Mr. Adams?
That's all I have, Your Honor. I have a big night coming up, Christmas Eve. I have many places to go at once, so they'll be excused.
You may be. Merry Christmas, Happy New Year to you, sir. Good afternoon, Mr. Schmidt.
Good afternoon, Judge.
Are you ready on, sir?
Better. Cody Ledbetter.
Ledbetter? All
Yes.
right. This is cause number CR 22-186 and 187, State versus Cody Wayne Ledbetter. Is it my understanding that we have an announcement on whether there's a plea or not?
We've reached an agreement. We're prepared to proceed with the plea, Judge.
All right, and can you give me the terms, Mr. Schmidt?
Sir, in CR 22-186, on a plea of guilt, the state's recommended sentence be assessed at 8 years TDCJ. $2,500 fine, 180 restitution to DPS lab, 290 court costs, and 105 reimbursement fees. It's got 176 days credit towards that sentence. In addition, they're agreeing to take CR 22-187 under consideration and under section 1245 Texas Penal Code. Also, I've just conferred with Ms. Heisel. He had 2 other cases. My understanding that the state has already declined those or rejected to prosecute. But for the record, we intend that this plea should tend to own Mr. Ledbetter's business in Van Zandt County.
Is that correct, State?
Yes, Your Honor.
Okay. All right, Mr. Ledbetter, if you'll raise your right hand, sir, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you. You can lower your hand. Mr. Ledbetter, are you a United States citizen who reads, writes, and speaks English?
Yes, sir. I am.
Have you been diagnosed with a mental condition before?
No, Your Honor.
In this case, you are represented by your attorney, Mr. Richard Schmidt. Are you pleased with him as your attorney?
Sir.
Do you feel like you have had enough time to talk with him about your cases, and you're satisfied that you've had all your legal questions answered?
Yes, sir.
Anything about the paperwork that you read over and signed today that you do not understand?
No, Your Honor.
And you agree with the plea agreement that Mr. Schmidt read to the court?
Yes, sir, I do.
Mr. Schmidt, do you believe Mr. Ledbetter to be competent today, and have you explained to him his rights as they pertain to these cases?
Yes, on both counts, Judge.
And you believe that he understands his rights and the waiver of those rights in the plea that he's taken today?
Yes, sir.
All right, Mr. Ledbetter, you are charged by indictment with what appears to be a second-degree felony offense of possession of a controlled substance in penalty group 1 or 1B in an amount greater than or equal to 4 grams but less than 200 grams. A second-degree felony carrying a range of punishment of not less than 2 years or more than 20 years confinement in prison, and a fine not to exceed $10,000. The court finds that the proposed plea agreement lawfully fits within the range of punishment. Mr. Ledbetter, how do you plead to that offense?
I plead guilty, Your Honor.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir, I am.
Mr. Ledbetter, has anyone threatened you, forced you, or pressured you to plead guilty today?
Your Honor.
The court accepts the defendant's plea of guilt. Mr. Schmidt, any objection to the state's evidence?
No objection.
State's evidence is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state,
No, Your Honor.
from the defense?
I'm sorry, Judge. Nothing from the defense.
Okay, no problem. All right, Ms. Heisel or Mr. Woodwright, can y'all give me the evidence to support the plea?
Yes, Your Honor. On November 24th of 2021, Wolves Point PD saw a vehicle make a left-hand turn without signaling. They attempted to pull that car over. Mr. Ledbetter was the driver of that vehicle. He took off and led them on a chase, hitting speeds of 135 miles an hour. He did eventually wreck out, climb essentially over the hood of the vehicle, and then evade on foot through a pasture. The officers were able to locate him, and they inventoried his vehicle and his person. And in the driver's side door pocket of the vehicle, they found a bag of meth, as well as on the hood of the car where they had seen him slide over to evade through that pasture. The lab tests the substance and it comes back at 4.47 grams of methamphetamine.
Thank you, Ms. Heisel. Any objections, Mr. Schmidt?
No objections, Judge.
All right, then based on the evidence presented, the court will find that there is sufficient evidence to convict Mr. Ledbetter. Court will follow the plea agreement reached with the state. The court hereby convicts Cody Wayne Ledbetter of possession of a controlled substance offender group 1 or 1B greater than or equal to 4 grams less than 200 grams, a second-degree felony. The court assesses his punishment at 8 years confinement in the Texas Department of Criminal Justice, orders him to pay a $2,500 fine, $180 restitution, $290 court cost, $105 in reimbursement fees, and the court awards Mr. Ledbetter 176 days credit towards his sentence for the time that he has spent in jail on this cause. And the court dismisses under section 1245 CR 22187 and evading arrest or detention with a vehicle. Mr. Ledbetter, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Good luck to you, sir.
If I may, before the court closes, I've gone through the stipulation of evidence and the lab appears to be missing. I think that's an error. I'm sure the state would want to submit that with states 1. If they want to submit it to states 2, we'd have no objection, but just so the court notes, it's not in the scope of that.
Thank you, Mr. Schmidt. State, will you be offering states 2?
Yes, Your Honor, we would offer that and I will physically bring it to the court for the inclusion at the conclusion of the docket.
All right, the court will admit states exhibit 2 without objection. And that states 2 will be the Texas Department of Public Safety Laboratory report for Mr. Ledbetter's case. Thank you for bringing that to my attention, Mr. Schmidt.
Sure. This is Derek James Silva.
All right, CR 22397. Mr. Silva is set for arraignment or possibly plea as well. Is that correct, Mr. Schmidt?
Judge, we're waiving formal arraignment. We're prepared to plea. We've got the paperwork ready to go.
Okay. All right. Can you go ahead and give me the terms of the plea, Mr. Schmidt?
Judge, in that cause, Mr. Silva will be pleading to an information of theft of mail less than or equal to 10 addresses. And that is a Class A misdemeanor. And the terms are that he be placed on 18 months deferred community supervision, assessed a fine of $1,000, 270 court costs, 515 reimbursement fees for court-appointed attorney's fees. In addition to that, the state has agreed to take into consideration DA 2022-1250 into consideration under the 1245 of Texas Penal Code.
All right, Mr. Silva, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Sir.
All right, you can lower your hand. Your name is Derek James Silva, is that correct? And Mr. Silva, you were set today for arraignment on the Class A misdemeanor offense of theft of mail less than or equal to 10 addresses. Class A misdemeanor does have a range of punishment of confinement in the county jail for a period not to exceed 1 year or 365 days, and a fine not to exceed $4,000. Mr. Silva, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
And in this case, you're represented by Mr. Richard Schmidt. Are you pleased with him as your attorney?
Yes, sir.
Feel like you've had enough time to talk with him about your case? And are you satisfied that your legal questions have been answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed today, Mr. Silva, that you do not understand?
No, sir.
All right, Mr. Schmidt, have you explained to Mr. Silva his rights, and do you believe he understands them, and do you believe him to be competent today?
I do on both accounts, Judge, and I've explained to him the consequences of the deferred.
All right, so Mr. Silva, then I'm going to ask you, how do you plead to theft of mail less than or equal to 10, I guess, items or addresses, a Class A misdemeanor?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right, the court accepts the defendant's plea of guilt at this time. Mr. Schmidt, any objection to state's evidence?
Objection.
All right, state's evidence is admitted and the court takes judicial notice of Mr. Silva's judicial confession. Anything further from the state?
No, Your Honor, we would rest and close at this time.
Anything further from the defense?
What's the close, Judge?
All right, state, can you give me the evidence to support the pleas?
Yes, Your Honor, on October 13th of this year, the Wills Point Police Department is made notified of multiple thefts from basically porches. Involves some bicycles, a box containing a spool of wire, and an Echo Dot that are in packages that have been delivered by a common carrier. They observed basically Ring doorbell video footage, and the Wills Point Police Department is able to identify the defendant. They go and interview the defendant, and he takes them and turns back over the stolen property at that time.
Thank you. Anything further, Mr. Schmidt, or any objections?
No, Your Honor. No objection.
All right, then based on the evidence, the court finds that there is sufficient evidence to convict Mr. Silva of this offense. The court will follow the plea agreement in this case. The court hereby defers a finding of guilt, places Mr. Silva on 18 months deferred community supervision, orders him to pay a $1,000 fine, $270 court cost, $515 in reimbursements, and the court dismisses under section 1245 DA 2022-1250. Mr. Silva, you understand that if you violate any of the terms of your community supervision, the state could file a motion to convict you and could ask the court to revoke your community supervision and put you into jail all the way up to 1 year. You understand that? All right. Step over with the deputy to be fingerprinted.
Judge, it's my understanding that we were attempting to bench warrant Ryan Augenstein, but he did not manage to get here, so that should conclude my business with the court this afternoon.
Is he the one that was in Dallas County?
Correct.
Yeah, I think Ms. Abraham brought that to my attention the other day. They were not wanting to release him, so didn't know if we wanted to follow up on that or just wait till they're done with their business.
Judge, I'll follow up with Ms. Abraham and state, but at this point, Dallas rarely honors those bench warrants, so.
Yeah, it's interesting. Rarely do they want to have court, and then rarely do they want to let
Anyone else?
anyone else have court. So
Thank you, Judge.
thank you, Mr. Schmidt. Have a Merry Christmas.
Yeah.
Mr. Ashmore, you ready?
Yes, Judge. Good afternoon.
Good afternoon.
Get part first, Your Honor.
All right, you said Jamie Hart, correct?
Yes, Jamie Hart, Judge.
All right, this is Jamie Floyd Hart, CR 22-146. For docket call, go ahead, Mr. Ashmore.
Judge, we're considering the state's offer. I've visited with my client recently over the last couple of weeks, telephonically this week. The current offer is 13 TDC. And we're just asking the court for an additional docket call so we can consider that, come back in early January, see if we can do anything else to negotiate this with the state of Texas or discuss our other options, going open to the court or some sort of agreement on a punishment range if that were to happen.
How long has Mr. Hart had the 13 years to consider?
Several weeks.
And what's the request? Is that the best offer the state's gonna make?
Judge, I believe, barring something major I don't know about, that is going to be the state's best offer.
Mr. Ashmore, do you have anything major up your sleeve that you plan on throwing at the state to convince them to change their offer?
Just to allow us some more time to talk about the option of waiving a jury trial, going open. That's a big, scary decision for any client, not one to be taken lightly. And especially one who might have a criminal history, et cetera, who's going to better weigh that and look at this offense, not in the light of perhaps other offenses in the past.
And Judge,
Go ahead, Ms. Hazel.
I will represent to the court that offer was made on November the 28th. So Mr. Ashmore has basically had that offer for just barely over 2 weeks. That was made right after Thanksgiving. So I know there's been some issues with jail on getting visitation and things like that. The state wouldn't be opposed to a very short reset.
Okay. The court finds that this is Mr. Hart's first docket call, so the court will make that request. Mr. Ashmore, are you available on January 5th?
I'm looking right now, Judge. Sorry, I'm having trouble with my calendar. Yes, Judge.
Okay. Court will set Mr. Hart then for docket call on January 5th at 1:30. And I'll look to hear if we have a plea agreement or request for a trial.
Yes, Judge. Thank you.
And Ms. Heisel, well, before we bring up the next inmate, I think you told me this and I may have either forgotten or not understand. On Mr. McFarland, you had mentioned the agreed protective order. Is that just going to be e-filed or sent over as an agreed order with everyone's signatures? So we didn't go over that with Mr. McFarland.
Yes, Your Honor, I gave that to Mr. Adams to take over to the jail. Mr. Adams and I had already signed it. He was going to get Mr. McFarland's signature. We did on the face of the protective order waive a record being made of that. So I don't think that'll be an issue. It should be included with the plea paperwork when it's brought back to the courthouse.
Great. All right, Mr. Ashmore, are you ready on Matthew Peters?
I am, Judge.
All right, Mr. Peters, if you'll come on up. This is cause number CR 21-304, State versus Matthew Ryan Peters. Show that we're set for pre-trial today. Also see that Mr. Peters has filed a concern with court-appointed counsel. Let's take up the pretrial issue first, Mr. Ashbourne.
Judge, we're ready to move to docket call. We've got all pretrial materials are requested and as I'm aware have been turned over. I've had a chance to visit with my client about it. He's well aware of all the discovery and the nature of the offense. The current offer is his choice, 10 TDCJ with no back time, 15 TDCJ with credit for back time and TDC between this case and present date because there was a prison sentence in between this offense and when this offense was indicted. And that actually leads right into the what the concern is that Mr. Peters is not satisfied that gotten him as good an offer as maybe someone else could get from the state of Texas, given his criminal history, that this is not his first DWI, third or more, that he's been down on an offense before. And I'll just leave it at that because I know Mr. Peters wants to address the court.
Okay, Mr. Peters, let's go ahead and let me see if I can summarize your complaints and then we're going to talk about those. You complain that you've only seen Mr. Ashmore one time in total. And that's over a period of 9 months. You've indicated that you believe that he's not listening to your part of the charge, or that and that he's not helping you get a fair offer. That he's not responded to your mother's numerous calls or returned the calls. That he has not contacted anyone at all regarding your case. That he's not representing you to your best interest. And that he does not talk with you about any offers, and that you only see him on the day of court if he shows up. And you've indicated that you want a fair lawyer. Let me go ahead and see if I can address some of these that we won't need to discuss further. Regarding your mother's numerous calls, Mr. Ashmore is not appointed by the court to represent your mother, and so he's not obligated to talk to your mother or anyone else about the case on your behalf. Okay. His obligation is to you as a client, not your mother. So I'm not interested in talking about that. With regards to helping you get a fair offer, you know that Mr. Ashmore does not make offers in the case. He can only make counter offers. And those are offers that you tell him that he's legally obligated or legally allowed to tell the state that you're willing to take. The state of Texas bears a burden in this case, and they bring the charge against you. They have the burden of proving you guilty if you go to trial, and it is the state and only the state that has the right to make an offer or accept an offer on their case. So Mr. Ashmore is not allowed to make an offer that the state then has to accept or reject. You understand that?
Yes.
Okay. All right. So let's take up these other issues. The visitation. You're part of the story. And I don't want you to disclose or say anything that could be used against you in court today, because the prosecutors are present. And if you say that you have a version of events or whatever that you say that he's not taking up, I would counsel you not to discuss that on the record in front of the prosecutors, because anything that you say today may be used against you later at your trial if you end up in trial. Do you understand that?
Yes, sir.
Okay. And let me ask you before you start giving me your reasons here. Do you have the ability to hire your own attorney, or does your family?
No, sir.
Okay. Have you talked to them about raising funds, taking out loans, doing over whatever they need to do to hire an attorney that you believe would represent you to the best of the ability that you want them to?
Yes, sir. I've talked to my mom, but it's not, she's on disability, so it's not able to help with that.
All right. All right. So go ahead and tell me the rest of your concerns and why you do not want Mr. Ashmore representing you.
It's just that I don't feel satisfied at all whatsoever. I've had him for 10 months since I've been in Collin County. I got the letter there stating he was my lawyer. Even getting here, until just recently, I haven't seen him hardly at all. He came and visited me one time and tried to video call me once, numerous times in one day, but that was only one day since then. The only other times I see him is when I'm here at court or whenever he comes up here to court. I don't feel, I've communicated my stuff with him even just recently, and I don't feel like he is putting my best interest forward first.
Okay. And tell me why that is.
We were just talking about this as well, and he told me he didn't even want to hear what I had to say, that he's already heard it before. Trying just to communicate with him at that part, it's just, for someone to tell me they don't want to hear what I have to say, to me, it doesn't seem like it's not good communication. I mean, at all, in my opinion. I feel like I'm the one who's about to have to face some time or anything of that sort. And for you to tell me you don't want to hear what I have to say, even if you've only heard it once before, because we've only spoken once about this, to me, it's not, I don't know that, I don't find that fair at all.
Anything else?
Not that I can recall off the top of my head, sir.
Mr. Ashmore, do you want to respond at all?
Judge, I don't go see clients out of county. I don't go to Henderson. I don't go to Tyler. I don't go to Collin County unless I'm, to see a court appointed client as a general rule. I didn't know where he was in the system. And if I had the information to let me know that he was in Collin County Jail at some point, if I were up there on a civil case or another criminal case, I would have stopped by. When I am talking to Mr. Peters, I think Mr. Peters feels like he wants to be understood. I totally get that. I don't need to hear the mitigating factors over and over and over again. What I need are decisions, because I know we're going to be right up in front of this court on this podium, and we're going to be asked to make decisions like, do we accept this plea offer or not? Are we going to do a jury trial or are we waiving it? Are we going open to the court or not? Or are we going to do punishment in front of the jury or not? And if I'm a little abrupt in the locker room, that's my job. It's my job to be the coach in the locker room. So when we're up here, we know what call and we know what play. And I don't think there's anything unethical or anything I'm ashamed of about that. I've been over the discovery with Mr. Peters. The facts they're hard, right? And it's a DWI third and it's not his first one. And that's a hard fact to overcome too. And the state of Texas is taking a strong position because of the nature of the offense. It's our number one most deadly weapon in the state of Texas is a motor vehicle. And our number one killer in the state of Texas is not diabetes. It's not cancer down in Beaumont. It's fatalities from alcohol related crashes. This couldn't be more serious. I get it. And I understand that the only person that these consequences fall on is Mr. Peters. And I've explained that to him and given him his options. I'm good with whatever the court's ruling is. I serve at the court's pleasure, but I also understand his frustration, right? Because he's in a jam and he is aware that it's the consequence of his own conduct and decision, and that it limits what we can do, because it's really not this offense, right? It's everything before it that locks us into these hard decisions. But it's my job to be the coach in the locker room. I don't need to hear all the mitigating factors over and over and over and over. I need decisions, and that's what I coach him to do.
All right, thank you, Mr. Ashmore. Mr. Peters, do you dispute Mr. Ashmore when he says that he's already gone over the discovery with you, that he's presented you with the options and he's discussed those things with you?
No, I do not. Not that.
Okay. All right, then the court is going to find, Mr. Peters, that nothing that you've indicated to the court today rises to the legal standard of believing that Mr. Ashmore is providing you with ineffective assistance of counsel, or that there's a deterioration of attorney-client communication to such the point that you would not be given a fair and zealous defense for this. So the court's going to order that Mr. Ashmore continue serving as your attorney in this case. And if the matter persists, then either one of you gentlemen will bring it to my attention. And Mr. Peters, if you are able to get your family to raise funds or friends or whoever, and you want to hire your attorney, please remember you're always welcome to do that. And you do have the right to hire anyone that you want. But as long as you're indigent, the court has appointed Mr. Ashmore, who is a licensed attorney in the state of Texas. And to this point, there's no evidence to suggest to me that he's done anything but what his professional responsibility requires him to do. Okay. So let's set this for, there are no contested pretrial motions. Is that correct, Mr. Ashmore?
I don't have any, and I don't anticipate filing any.
All right, then the court will set this for docket call. And I can set it sooner or I can set it later, Mr. Ashmore, depending on how much time you and Mr. Peters need to make the decisions that you need to make in the case. So we could set as early as January 5th, or we could set, January 24th or even into February.
Judge, I'm going to ask for the forth because we clearly have some things to work through. And I'm open that day, so that'd be my respectful request.
All right, the court's going to set Mr. Peters for docket call on January 24th at 1:30. If Mr. Peters, if you make bail, then your hearings will be at 9 a.m., sir.
Thank you, Your Honor. May I be excused?
Yes, thank you, Mr. Ashmore. You may.
Matt. Matt.
We have any other attorneys that are ready?
Your Honor, I believe this remaining is ready with a couple of minutes.
All right, don't let Mr. Sanders go to sleep back there. He looks pretty comfortable.
Manny would like all his relief denied, Judge. Merry Christmas.
Merry Christmas. All right, Mr. Manning, who are you ready on, sir?
Start with Mr. Logan.
All right, this is cause number CR 1923, State versus Justin Edward Lee Loden. Motion to revoke. Go ahead, Mr. Manning.
Judge, the state and I have been in negotiations and we're real close on, I think something getting worked out. We're seeking a dual diagnosis program for Mr. Loden. Part of his struggles on probation were based and due to his mental health situation. And so what we're trying to do is find something that will address that, and hopefully the other things will fall into place. And so I've been in conversation with the state as well as the probation department. We're working on something. We'd ask for a short reset to see if we can get something worked together for him to get put on as an amended condition of his probation.
The shortest I've got, that's a Thursday, would be that January 5th. I don't know how much time that gives you.
Judge, that'll give me enough time to at least have a proposition together, see if we can get that agreed to by the state.
Okay.
Judge, and I would just suggest if we could set it for both the 5th and then like I think the contested docket is the 26th. Just that way, if we reach an agreement on the 5th, we can get it done. If not, we'll already have it set, as long as Mr. Manning doesn't object to that date.
Judge, that'd be fine.
All right, then the court will set just a status hearing on the motion to revoke or adjudicate January 5th. That'll be at 1:30. If we have no resolution, we'll go ahead and set it today for the contested hearing on Thursday, January 26th.
Judge, I'm ready for Mr. Boylan.
All right, Mr. Boylan. This is cause numbers CR 22-88, -167, -168, 169, 170, State versus Gerald Robert Boylan. Go ahead, Mr. Manning.
Judge, we're here on a status for Mr. Boylan's competency restoration. At this point, Mr. Boylan has not made it to a facility to begin competency treatment. I've looked at a couple of different options with Mr. Boylan. Actually contacted me late last week or early this week, last Thursday, requesting that I examine an additional hospital, but I'm unable to confirm the doctor and situation that he requested. He provided me a letter today that he was willing to read to the court about his mental health situation and how it stems from when he was a young kid, a baby, and physical trauma that happened in utero and as a young baby. And so I don't know if the court, I'm examining the letter as we speak. I was just giving it. I don't know if the court would like me to forward this letter to the court. I don't see anything in there that would harm my client's legal position, and it may be informative to the court. And so if it's all right with the court, I'll bring that this afternoon with the resets.
Yes, let's do that. They'll give you time to review it, and then if you want it to be filed of record, we can do that as well. We could even seal it if we need to, if it's concerning mental health. That way it's part of the record for any kind of review later.
Yes, Judge. When would we like to set Mr. Boylan next?
What about that February 9th date, Mr. Manning?
Judge, that'll work for me.
All right, so Mr. Boylan, we're gonna set you again for status on your restoration on February 9th, okay?
Okay,
Are you doing okay over at the jail?
I'm having a few problems, Mr. Martin, and I'm glad to ask. There's a couple of the officers here. I told Mr. Martin about it. And now I'm glad we got a new captain. The captain told me to bring it up next time I go to court. So there's 3 officers that's been picking on me, literally picking on me. And captain's talked to him. I've talked to him as nice as I can. Mr. Manning told me try to ignore it. I've tried. Judge Martin, the 3 officers it is the first one is Jonathan Davis. The second one is Mims. And the third one is on the night. He's a sergeant. He's Lockhead.
What was the last one?
Sergeant Lockhead.
All right, okay. Okay, and how are they picking on you, Mr. Boylan?
I like I'll ask for like some paper and stuff, or I'll ask for the like grievance because the cell I'm in doesn't have a kiosk, so I have to use the intercom button to request for request forms, seek call forms, all that. And when they're working, they don't want to do their job. They totally ignore me, all 3 of them.
And is that how you believe they're picking on you?
Yeah, and there's also afternoon has been like when me and Mr. Manning first met, he told me don't say nothing about your charges. Well, Mills has been going around telling all the inmates, and it's come back to me that he's been going around telling everybody, showing my charges off of that little monitor thing and everything.
Okay. All right, I will discuss this with Mr. Manning and the state, and then we can have contact with Sheriff Carter as well, and we'll see if we can get to the bottom of that for you, Mr. Boylan. Okay.
February 9th for status on.
I got a pin.
Okay.
Because they said they want us calling Josh pins. Gotcha. Because right now it's real COVID in the jail right now.
Gotcha. Well, I appreciate that. And I'll pass on the letter to Judge Martin.
And Mr. Manning,
Did you hear? Oh, okay.
You okay? Yeah. Well, All right, Mr. Manning, who are you ready on now?
Judge, Mr. McInturf. He was originally set on a writ hearing, a 17, 15, and 151. And the court withheld making a ruling at that point in time, and denied relief in part, and then held off. He has passed his 90 days, and the state's in agreement. And so we were just here to have whatever procedural things need to happen for his release on the agreed 90-day writ.
Okay, tell me again what Mr. McIntyre was accused of. Is
Uh,
that-
Oh, go ahead, Mr. Manning.
Well, Judge, since he's on the docket, I don't have all the information right in front of me. We have not received a case file, nor have we received anything from the state that's been probable cause affidavit, anything like that. And so any information we have best be coming from the state.
Go ahead, Mr. Woodward.
I'm pulling up right now. Judge, Mr. McInturf is being held on a state jail possession of controlled substance penalty group 1, less than 1 gram, state jail, and a tampering, fabricating with physical evidence with intent to impair, a 3rd-degree felony. State has not, as of yet, received a case on either of these cases. It does appear as though he was arrested August 1st of this year. What information we have is that it is a sheriff's office case, but we have not received a formal case on either of these charges.
All right. Court will find Mr. McIntyre has not been indicted by the state within 90 days, is entitled to be released under Article 17-151. The court will grant the personal bond at $7,500 in each charge. And the court will, I believe the court will sign that order on bail. Mr. Manning, didn't you already sign a proposed, or did you file a proposed order with your writ?
Yes, Judge. I filed that and I finally filed the writ. And if you like, I can forward a copy of that once I get back to my office.
No, that's okay. If you've already filed it, I'll go find it and I'll get that signed today at the end of the docket.
Thank you, Judge. Thank you, sir.
You're welcome.
You need a moment? I'll get you Mr. Sanders. I told Mr. Sanders he's more welcome. Okay, Mr. Wetcher, that's fine with me.
All right, I know we got one.
All right, you've been here longer than I have.
Yes, I have.
All right, is this Mr. Downs?
Yes, sir, it is.
All right, this is cause number CR 2210, State of Texas versus Joel Hinton Downs. Mr. Downs, have you lost weight, sir?
Yes.
You have, yeah, you look a lot different. All right, Mr. Downs, if you'll raise your right hand, I mean, you look better, is what I'm saying. I didn't recognize you when you walked up. Mr. Downs, do you swear that the testimony that you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, thank you. You can lower your hand. All right, Mr. Downs, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with any type of mental condition?
No.
And in this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with his representation of you?
Yes.
Feel like you've had enough time to talk with Mr. White about your case and that you're satisfied you've had the answers to all your legal questions?
Yes.
Is there anything about the paperwork that you've read over and signed today that you do not understand?
No.
Mr. White, do you believe Mr. Downs to be competent? And if so, have you explained to him his rights concerning this plea agreement?
Your Honor, I believe that Mr. Downs is mentally competent, understands the proceedings that are pending against him here today. I believe that he's executed his waivers of his rights knowingly, intelligently, and voluntarily.
All right, Mr. Downs, you are charged by indictment with a third degree felony offense of theft of service greater than or equal to $30,000, less than $150,000. I see here that the plea agreement is to state jail division. Is that correct?
That's correct, Your Honor.
All right, and so state, on my judgment of conviction, it says third degree felony. And
Yes, Your Honor, we've sent an updated copy out to the jail.
Okay. All right, so I see the plea agreement is that Mr. Downs would plead to a lesser included offense of theft of service, and what is that? $2,500 to $30,000, a state jail felony. And punishment recommendation is 9 months confinement in the state jail with restitution in the amount of $20,575.45 plus court costs, reimbursements, and Mr. Downs would receive 305 days credit towards the sentence for the time spent in jail. Is that correct?
That's correct, Your Honor.
And Mr. White and Ms. Heisel, on the copy of the front page of the judgment that was left for me, I noticed that in the restitution portion in the plea agreement, it says 20,000, but in the restitution section down here, it says 75.
Yes, Judge, we've also updated that. We've had a couple different versions of the judgment today.
Okay.
Yes,
So
you will.
long, all right, so long as that's corrected. All right, so Mr. Downs, you understand what you're charged with and you understand the plea agreement. Is that right, sir? All right, so Mr. Downs, at this time, I would ask you, how do you plead to theft of service greater than or equal to $2,500, less than $30,000, a state jail felony?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime and for no other reason?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty to this offense?
Yes, sir.
All right, the court will accept the defendant's plea of guilt. Mr. White, any objection to the state's evidence?
No, sir.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Yes, Your Honor, just a couple of things. First, we just want to state for the record that we are in compliance with victim notification. The victim has been in contact with our office multiple times. I haven't spoken to him particularly about the plea offer today, but based on my previous conversations with him, he would be supportive of this plea. He had provided restitution documents to us, and Mr. White presented on Mr. Downs's behalf a receipt showing that he had paid partial restitution back, about $10,000 worth, which is why we changed the charge from a third degree to a state jail to reflect the remaining balance that is owed in restitution, which is about, I believe it's 20,500, and then the rest of the reimbursement comes from court costs.
And Mr. White, I noticed that, sorry, just some feedback. I noticed that Mr. Downs was shaking his head regarding the restitution. Is there an issue?
No, sir. Ms. Heisel said it was about 10. It was over that. It was 11, but we're satisfied with what the restitution amount is, as far as it reflects what Mr. Downs had paid back.
Okay. And so what's reflected in the judgment, is that the total owed now, or is that the total owed altogether with credit for 11,000?
No, Your Honor, that's what remains.
Okay, thank you. All right, anything further from the defense, Mr. White?
No, sir.
All right, and Ms. Heisel, can you give me the facts that support the plea?
Yes, Your Honor. Mr. Downs purchased some concrete from a concrete company and then essentially stopped payment on the check. As we stated before, that check was for a little bit over $31,000. However, he made partial restitution after this became a criminal case. Mr. Downs was provided ample opportunity to provide payment for that service, but did not return any of the notices that were sent to him, which is how it came to be filed as a criminal case, Your Honor.
All right, thank you, Ms. Heisel. Any objections to that summary, Mr. White?
And further to add, Your Honor.
Thank you, sir. All right, then based on the evidence presented to the court finds that there is sufficient evidence to convict Joel Hinton Downs of theft of service, $2,500 to $30,000. The court will follow the plea agreement in this case, convicts the defendant of that offense, assesses his sentence at 9 months confinement in the State Jail Division of TDC. Court will order him to pay restitution in the amount of $20,575.45, $290 in court costs. Court will also order him to pay $125 in reimbursement fees. And the court will award Mr. Downs 305 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Downs, you're hereby remanded to the custody of the sheriff so we can carry out the terms and conditions of the sentence. Good luck, you, sir.
Mr. Downs.
Go ahead and step over with the bailiff to be fingerprinted, Mr. Downs.
Mr. Sanders.
Mr. Sanders, I believe you're the next victim.
All right, Judge.
Who do you want to start with first?
Hey, we can go and do Mr. Ellis first.
All right, Mr. Ellis, Donald Brian Ellis, CR 19305. I believe that we set today for status on the DNA testing. Go ahead, Mr. Sanders.
That's correct, Judge. And Judge, I know we had a discussion during the morning session of court. I told Mr. Ellis about that. I checked earlier in the week with Swifts about the status with the DNA testing. And it's not completed yet. And I think there's some confusion on my part where I didn't go ahead and get I didn't realize the court had already signed one order. And I didn't go ahead to get that sent to Swifts. But now that we've got that previous order and in the order now, that also includes the court date that they will want to have to kind of know how to schedule the testing, then I'll go ahead and get that email to Stacy McDonald, I believe is the contact person. So I'll get that email to her today, and then we can get things moving towards getting the testing done.
Okay.
And I think we have October 2nd special setting on the case.
Okay. Do we need to set? I think we do need to set it for status on the DNA. Let's set it in March.
Okay.
And see if we can we need to make sure we have it in ample time before the trial. Looking at, you thinking before spring break or after spring break, Mr. Sanders? I know you have kiddos and thought you may be out for that spring break week.
Yes, I'd say probably after, like towards the end of March, that should be fine.
What about March 28th?
Yes, that'd be good.
All right, court will set Mr. Ellis then for status on DNA testing March 28th. That'll be at 1:30. Make sure there's conditions of pretrial release and you just mark on there, right on there. Defendant was signs conditions of pretrial release before they like. Might be get standing with that. Who are you ready on next, sir?
Judge, we can do Miss Lewis next.
All right, Kristen. Is it L'Oreal? Is that right? I may have marked it. Is that how you say that, L'Oreal?
Laurel.
Yeah, that's what I said, L'Oreal. Right?
Yes.
Yeah, no, I didn't say it. Kristen Laurel Lewis, and we are set for pretrial and maybe a plea. Is that correct, Mr. Sanders?
That is correct, Judge. We have a plea agreement in this case. The agreement is for 86 days, Van Zandt County Jail under 1244A with $4,000 fine, $180 in restitution, and then 1245, the unauthorized use of motor vehicle, which is DA number 2020-1071. And then she has 86 days credit.
Is that going to be a 270 court cost or a 290 court cost?
290.
290. Any reimbursements?
Yes, Judge, actually, I think what's listed here, on the judgment 585, which I think includes the court appointed attorney's fees, and actually, I think technically the court appointed attorney's fees would be 650, because there's the UUMV that's being 1245.
Okay, so your claim's going to be such that the reimbursements would be 650.
Yes.
Okay, so what we'll need to do is, I'll mark through the judgment and I'll fix that. So have you discussed that with, Ms. Lewis?
Yes, Judge.
Okay, so she knows there's an increase in what is reflected on that judgment.
Yes.
Okay. All right, and her original charge was possession, less than one, correct?
That is correct.
Okay, Ms. Lewis, if you'll raise your right hand, I'm going to place you under oath. Ms. Lewis, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Lower your hand. Just make sure you speak up loudly and clearly for me. Your name is Kristen Laurel Lewis, is that correct?
Yes, sir.
And Ms. Lewis, are you a United States citizen that reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jeff Sanders. Are you pleased with him as your attorney?
Yes, sir.
Do you feel like you've had enough time to talk with him about your case and to the point that you're satisfied you've had all your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read over and signed today that you do not understand?
No, sir.
Mr. Sanders, do you believe Ms. Lewis to be competent? And if so, have you explained to her her rights as they pertain to this plea agreement?
Yes, sir. I believe she is competent, and yes, we have gone over all her rights.
All right, Ms. Lewis, you are charged by indictment with a state jail felony offense of possession of a controlled substance in penalty group less than 1 gram. And that plea agreement in this case would be for the prosecution to proceed under section 1244A. So what that means is, Ms. Lewis, if I follow the plea agreement, you would be convicted as a felon today, but you would be punished as a misdemeanor offender with your jail at 86 days, meaning that if it's prosecuted under 1244A, you couldn't receive more than 1 year in jail. And I see here, based on the plea agreement that Mr. Sanders has read, that your sentence would be at 86 days in jail. You would receive a maximum fine allowable under the law at $4,000, plus your court costs and reimbursement fees. Do you understand the plea agreement and the range of punishment?
Yes, sir.
And you do understand that you would be a convicted felon after this case?
Yes, sir.
Okay. And do you have any questions about that?
No.
Okay. All right, then I'm going to ask you, Ms. Lewis, then how do you plead to possession of a controlled substance in penalty group 1 less than 1 gram?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes.
Has anyone threatened you, forced you, pressured you to plead guilty?
No.
Court accepts the defendant's plea of guilt at this time. Mr. Sanders, any objection to the state's evidence?
No objection.
The state's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we would rest and close.
Anything further from the defense?
No, Your Honor, rest and close.
Mr. Sanders, will you make sure that there is a lab report in states 1 while Mr. White or Mr. Woodwhite gives me the summary of the state's evidence to support the plea?
Yes, Your Honor. On the date in question, which is October 31st of 2020, the defendant calls for a tow truck in the Walmart parking lot here in Canton. The tow truck driver gets ready to tow the vehicle, but notices that the ignition has been drilled and calls the police. The police arrive and run the car and find that it is stolen. They search the vehicle and find in a bag 0.19 grams of meth along with the defendant's ID.
Any objection to that summary, Mr.
No
Sanders?
objection. And Judge, I don't lab result in the stipulation of evidence.
Judge, I would move to admit State's Exhibit 2, which is the lab result that has been turned over to Mr. Sanders. I don't know why it was not included. It does show 0.19 grams of methamphetamine.
Any
And we
objection?
don't,
All right, there being no objections from the defense, State's Exhibit 2 lab report is admitted. And the court will find that based on the evidence presented, there is sufficient evidence to convict Ms. Lewis of this offense. Court will follow the plea agreement in this case. The court hereby convicts Kristen Laurel Lewis of possession of a controlled substance in penalty group 1 less than 1 gram. The court assesses her punishment under section 1244A of the Texas Penal Code at 86 days in the Van Zandt County Jail. The court will award her 86 days credit for the time that she has previously spent in jail. Court orders her to pay a $4,000 fine, $290 court cost, $180 restitution, $650 in reimbursement fees, and the court will dismiss DA 2020-1071, unauthorized use of a motor vehicle. So Ms. Lewis, whenever you get out of jail, if you get out before 5 p.m. today, I need you to come over to the courthouse and meet with a court compliance officer so you can make arrangements to set up a payment plan to get these fines and other fees paid off. Your failure to do that, and if you don't get out before 5 today, then you need to call the court compliance officer, set up an appointment, or just come into the courthouse anytime, Monday through Friday, 8 to 5. And set that up. If just know that we're coming up on the holidays, so you may want to call ahead before you just drive from wherever you're from. Okay.
Okay, thank you.
All right, Miss Lewis, step over with the bailiff to be fingerprinted. All right, Mr. Sanders, you ready on Mr. Petty?
yes, sure, we are.
Scotty Dale Petty, CR 21365. Is this going to be a plea today, Mr. Sanders?
Yes, sure, it is.
All right, can you go ahead and give me the terms?
Yes, Mr. Petty will be pleading guilty to the lesser included charge of a Class A assault family violence. This will be for a sentence of 209 days in county jail with credit for 209 days, $1,000 fine, and then court cost of $270. And then the court appointed attorney's fees are $750.
Did you say 290 or 209 on the sentence?
Oh, 209.
20. Okay. He probably doesn't want me to assess 290
No, I don't think
if he
so.
doesn't have 290. Okay. All right, Mr. Petty, if you'll raise your right hand, sir, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, you can lower your hand. All right, Mr. Petty, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jeff Sanders. Are you pleased with his representation of you?
Yes, sir.
Do you feel like you've had enough time to talk with him about your case and that you're satisfied that you've received answers to all your legal questions?
Yes, sir.
Is there anything about the paperwork that you've read over and signed today that you do not understand?
Yes.
All right, Mr. Sanders, do you believe Mr. Petty to be competent today and if so, have you explained to him his rights as they pertain to this plea agreement?
Yes, sure. I believe he is competent, and we went over his constitutional rights regarding this, the case and plea agreement, and I believe he understands all those rights.
All right, thank you, Mr. Sanders. Mr. Petty, you were originally charged with a third-degree felony offense of assault of a family or household member with a previous conviction. That's a third-degree felony. However, the plea agreement in this case calls for you to plead guilty to a lesser included Class A misdemeanor assault family violence. The range of punishment for an assault family violence Class A misdemeanor is jail time not to exceed 365 days and a fine not to exceed $4,000. I see here that the proposed plea agreement fits legally within that range of punishment. Understanding the range of punishment, understanding the plea agreement, do you still wish to go forward?
Yes, sir.
Okay. All right, Mr. Petty, then how do you plead to assault family violence, a Class A misdemeanor?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right, the court does accept the defendant's plea of guilt at this time. Mr. Sanders, any objection to state's evidence?
No, Your Honor.
All right, state's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, with regard to victim notification, state is in compliance. However, we have nothing to present to the court at this time from the victim.
Thank you, Ms. Heisel. Anything further from the defense?
No, Your Honor.
All right, go ahead and give me the facts to support the plea, Ms. Heisel.
Yes, Your Honor. On June 25th of 2021, law enforcement is asked to do a welfare concern at Mr. Petty and his girlfriend's travel trailer. They both are interviewed by officers separately. They both agree that there was an argument ongoing that was verbal. The victim says that Mr. Petty hit her in the face with a full can of beer. And Mr. Petty said that he never laid his hands on her. However, she does have a swollen / busted lip, dried blood around her mouth and chin area. They go inside the camper and on the floor is a full can of unopened can of beer consistent with her story.
Thank you, Ms. Heisel. Anything further from the defense, Mr. Sanders?
No, Your Honor.
All right. And based on the evidence presented to the court will find that there is sufficient evidence to convict Mr. Petty of this offense. The court will follow the plea agreement between the state and the defense. Court hereby convicts Scotty Dale Petty of assault, family violence, class A misdemeanor, assesses his punishment at 209 days confinement in the county jail, awards him credit for 209 days of time already served. The court orders him to pay a $1,000 fine, $270 court cost, and $750 in reimbursement fees. Mr. Petty, the same thing that I told the young lady before you. If you get out of jail before 5 today, I want you to report over to the courthouse, meet with the court compliance officer to set up a payment plan to discharge what you owe. If you don't make it out before 5 today, then sometime between 8 and 5 tomorrow, you need to come in and take care of that. And your failure to comply with either a payment plan or just discharging what you owe all at one time will result in the court issuing a warrant for your arrest. Okay.
Sir.
All right. Step over with the deputy and you'll be fingerprinted.
That's all I have, Judge. May I be excused?
Yes. Thank you, Mr. Sanders. Good to see you. Merry Christmas. Happy New Year.
Yeah, Merry Christmas.
All right, Mr. Manning, who are you ready on?
Judge, I can take Mr. D'Anthony Smith.
All right, Mr. Smith. Cause number CR 21-144, motion to revoke. Go ahead,
Judge,
Mr.
I was just appointed on this case on Tuesday. I had a chance to briefly discuss Mr. D'Anthony's situation today at the jail. I'm also planning on visiting him tomorrow to get a more full understanding of the picture, begin negotiations. If we go ahead and reset this for the January 26th contested docket, and then if we get a resolution in the meantime, that would be benefited by setting him earlier, I'll let the court know.
All right, the court will set Mr. Smith for the contested docket on January 26th. That will be at 1:30. If there is a resolution before then, court does have some availability on his docket, and you'll just let me know, Mr. Manning.
Thank you, Judge. Next, somebody on Mr. Gutierrez.
Mr. Gutierrez. All right, this is cause number CR 2169, State versus Damon Jacob Gutierrez, motion to revoke. Go ahead, Mr. Manning.
Yes, Judge. We would also request the January 26th setting on his case as well.
All right, the court will set Mr. Gutierrez for contested hearing on January 26th if a resolution is not reached sooner or on that day.
Thank you, Judge. And then Mr. Jonathan King.
Jonathan Cantrell King, CR 22-331, CR 22-332, show that we're set for arraignment in both cases, I believe.
Yes, Judge, and I have not seen a copy of the indictment or discovery in this case. If we could take a look at that.
Sure, let me get you pulled up just a moment. Can you see that, Mr. Manning?
Yes, Judge. Judge, his name is spelled correctly. He understands the charge against him as well as the range of punishment. Please not guilty to this case.
All right, court is having cause number CR 22-332 indictment displayed for the benefit of Mr. King. Let me make that.
Judge, he pleads not guilty this time. His name is spelled correctly. He understands the charge against him as well as the range of punishment. We were asked to be set on the pretrial docket.
All right, court will find that Mr. King has waived the formal requirements of arraignment. Court will enter his plea of not guilty into each case respectively, and the court will set each case for pretrial hearing February 9th, Mr. Manning.
Yes, Judge.
All right, court sets Mr. King for pretrial February 9th, each case. Hearing will be at 1:30. Mr. King, if you make bail in this case, your hearings will be at 9 a.m. in the morning, okay?
Judge, if we can get Mr. Dallas Vigil.
All right, Mr. Vigil. CR 21-251 and 257, State versus Dallas, Anthony Vigil. Show that these are motions to revoke. Are we set for plea today, Mr. Manning?
Yes, Judge. We're going to be proceeding on both the DWI as well as the other case.
All right, give me just one moment so I can I'm gonna pull up both of his motions. All right, Mr. Manning, are you able to see that state's amended motion in cause number CR 21-251?
Yes, Judge, and we've reviewed both the motions, and my client understands he's gonna be pleading true to all but the final count, which the state's abandoning. That is a violation under condition A. And they're proceeding on the remainder, and he's ready and willing to plead true to those.
All right, so say that again. Which one are they abandoning and he's not pleading true to?
Judge, it is gonna be, forget the number on it. It is count 7, condition A. They are abandoning that, and I've struck it from the paperwork.
And that's the polygraph test.
No, Judge, that is the alleged new offense in mis-
All right, because count 7 in cause number CR 21-251 is a polygraph allegation.
And Judge, he's actually going back on probation in 251. On 257, they are terminating his probation and continuing. Sorry, on 257, they're terminating. On 251, they're amending and continuing on his probation.
Amend, continue. 251, and then withdraw, terminate on 257. Is that right?
Just revoke and terminate, Judge.
Revoke and terminate. What does that mean? Revoke. So what's we're gonna revoke him and then terminate his community supervision? We gotta do one or the other.
Mr. Manning, will you read Judge, essentially, there is a plea true. We are abandoning the new offense in both of these causes. I think they're different numbers and different motions. But the new offense, we are abandoning. On the DWI 0.15 charge, we are going to plea true and revoke him. And I'll let Mr. Manning fill out the details in terms of the days and fine amounts. And then in the felony charge, the 251 charge, we are going to withdraw and continue with an amendment for him to go to the inpatient teen challenge program as a condition of his probation.
Okay, so the plea true revoke, what are the terms of that CR 21-257?
Upon the plea of true to state's motion to revoke, defendant's community supervision will be revoked. Punishment assessed at 182 days confinement in Van Zandt County Jail with credit for time served, amounts of financial obligations. The fine on that is $100. Court costs are $270, and reimbursement is $135.
All right, so in cause number CR 21-257, the state is abandoning count 7 in this one, wherein it's alleged that he intentionally fled from a Mesquite officer.
That's correct, Judge.
Okay. Okay, all right, Mr. Vigil, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. All right, Mr. Vigil, you appeared before the court. Let's get over here to it. You appeared before the court on cause number CR 21-257 on February 10th of 2022. You pled guilty to driving while intoxicated, a Class A misdemeanor. Court heard the evidence, assessed your punishment pursuant to a plea agreement at 1 year confinement in the county jail and a $100 fine. The court suspended the sentence, placed you on community supervision for 2 years. It was during that period of 2 years that The state has filed an amended motion to revoke your community supervision, and they have alleged in 7 separate counts ways that you have violated your community supervision. The court notes the agreement is that the state is abandoning count 7. So as to counts 1, 2, 3, 4, 5, and 6, Mr. Vigil, how do you plead to those counts? Are those counts true or not true?
True, Your Honor.
And you're pleading true to those because what they alleged is in fact true. Is that correct?
Yes, sir.
Has anyone threatened you, forced you, pressured you to plead true to any of these counts?
No, sir.
And I didn't ask you, but are you pleased with Mr. Manning as your attorney?
Yes, sir, I am.
Do you feel like you've had enough time to talk with him about this plea agreement? And also to the point where you've had all of your legal questions answered?
Yes, Your Honor.
And Mr. Manning, I assume that Mr. Vigil is competent today, unless we wouldn't be going forward, correct?
That is correct, Judge.
All right, court will accept Mr. Vigil's pleas of true. And I'm assuming that the probation department is supportive of these pleas. Is that correct?
Yes, Your Honor. We have coordinated with them, particularly in the teen challenge being added as a condition of probation, and they do support that.
Okay. All right, then based on the defendant's pleas are true and the evidence, the court finds that Dallas Anthony Vigil has violated the terms of his community supervision, NCR 21-257. Court will follow the plea agreement in that case. The court hereby revokes his community supervision, orders or assesses his sentence at 182 days confinement in the Van Zandt County Jail. Will in revoking his community supervision, also give him 182 days credit towards that sentence and order him to pay the balance of his financial obligations. In CR 21-251, the court will grant the state's motion to withdraw, and the court will amend Mr. Vigil's community supervision to include the agreed upon inpatient program. So Mr. Vigil, you still owe the county a lot of money. So you're still on probation in your felony charge, but you still owe money in your misdemeanor charge. I don't know if there was any agreement to roll what he owed in the misdemeanor into the felony. If not, then Mr. Vigil, you need to make arrangements to continue to pay what you owe on that misdemeanor case. Otherwise, what will happen is you'll get a warrant issued for your arrest out of the courthouse that the probation department might not know about. Okay. So when you get out of jail, you need to come over to the courthouse and make arrangements to get on a payment plan so you can pay off what you owe while you're also paying on what you owe in probation. Do you understand?
Yes, sir, I understand.
Okay.
And Judge, just to explain to the court, Mr. Vigil's going into a year-long inpatient treatment program. It's going to be intense, supervised, and then he's also going to be on ISP once he gets out. Part of the program is teaching him basic life skills like how to balance a budget and how to take care of his financial responsibilities. And so for the first 7 months, he'll be working, but won't be earning any money. In those last 3 months, he'll be earning money and putting that money towards saving it up for once he gets out, be able to pay for transportation, for residency, as well as pay his obligations to the community supervision department, as well as Van Zandt County. So hopefully we're setting him up for success with this program, and then teaching him the skills he needs to continue to be successful after he gets off probation.
When does he go into that program?
Judge, he's going straight to that program from release here. There is an intervening issue that's going to have to be taken care of in Collin County that we're working on, either him being transported directly from Van Zandt County or him being picked up and taken there. But I've been coordinating both with his attorney, Ms. Keever, in Collin County, as well as the court system there, as well as Teen Challenge to coordinate him going directly from custody to the program.
All right, so it's gonna be my suggestion that someone contact the court compliance office here and let them know where Mr. Vigil is gonna be. If he's not gonna be able to come and do it himself, that gets done. Otherwise, due to the nature of the process, his name's gonna fall between the cracks. And if letters are being sent out to addresses that he's not at and he's not being communicated, they may think that he's in the wind. So
Absolutely. I'll reach out to Ms. Bonnie and coordinate that with his family.
All right, thanks, sir. All right, Mr. Vigil, step over with the deputy and be fingerprinted. You want next, Mr. Manning?
Judge, if we can call it Mr. Christopher Laney.
Christopher Glenn Lamy, CR 21-298, motion to revoke. Go ahead, Mr. Manning.
Judge, today we received a amendment to the conditions of probation to withdraw and continue him. And that amendment is to reflect the change in his court cost, as well as what is that time in the total amount of 143 days.
All right, and probation is approved.
Yes, Judge.
All right, Mr. Lamy. Have you raise your right hand? Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God? All right, you can lower your hand. All right, Mr. Lamy, so I heard what Mr. Manning said. Did you hear what he said? Did you hear what Mr. Manning
Yes,
said?
sir.
Okay, and you understand that if the court grants this amendment, that your back time will be taken away from you. That means if you are later motions filed and you're sent to prison later for additional violations, that you're not going to get credit for any of the time that you've spent in jail on this amendment. You understand that?
Sir.
And you also understand that you're going to be responsible for the new attorney fees and court costs based on that motion to revoke. You understand that as well?
Yes, sir.
And that's the agreement that you've entered into and what you want the court to approve. Is that right? And has anyone pressured you or forced you to do that today?
No, sir.
And you're pleased with Mr. Manning's representation?
Yes, sir.
And you understand all of the paperwork you signed and you don't have any questions about what we're doing?
I'm good, sir.
Okay. And you understand that this court's not going to continue to grant amendments for violations. You understand that? Okay. As long as we're clear, all right, the court will approve, the court will grant the state's motion to withdraw. The court will amend the community supervision conditions to include the 143 days in jail as a condition of community supervision, in addition to the new court costs and attorney fees.
And Judge, if I may, just by way of support for the plea, Mr. Laney, since being put on probation, has actually experienced 2 heart attacks, and has had a heck of a time trying to recover from that and other side effects or illnesses from the heart attacks. He is in a better place now, both physically and socially stable, to get to and from probation, do what he needs to. And so I think he's in a better position to be successful on his probation.
Thank you, Mr. Manning.
Judge, if we can call Mr. Skinner.
Andrew Skinner, CR 18-507. This is motion to revoke.
Yes, Judge. We'd ask to be set on that January 26th date.
All right, court will set Mr. Skinner for contested hearing on January 26th if a resolution is not had before then or on that day.
We're on Mr. Murphy.
Michael Murphy, CR 22-153, arraignment.
Judge, we've had an opportunity to go over the indictment. He understands the charges against him as well as the range of punishment for those charges as alleged by the state. His name is incorrectly spelled on the indictment as well as the header, and that should reflect Michael spelled Micheal.
Judge, state would make an oral motion to amend the indictment to reflect the correct spelling of Mr. Michael David Murphy's name.
Any objections?
No objection.
All right, there being no objection. Court grants the state's oral motion to amend the indictment for the correct spelling of Michael to Micheal. Court will amend the indictment to reflect that correct spelling. Court will find that Mr. Murphy has waived the formal requirements of arraignment. Court will enter his plea of not guilty into the record. We'll set this matter for pretrial on February 9th.
Judge, I don't see that Mr. Byrd is here. I believe he was set on status for TDC bench warrant. We've reset him to January 5th, I believe. In which case, at that point in time, I believe I'll have a resolution on his case. I've spoken to the state. I don't anticipate any difficulty getting that resolved on that date.
Okay, court will set Mr. Byrd for January 5th for plea.
And Judge, I believe it is already set for the 5th via email between myself, the court coordinator, and the state.
Great, thank you, Mr. Mann.
And Judge, if I may just have a moment to speak to Ms. Martin before we announce our case.
Absolutely.
Thank you, Judge.
Good afternoon, Your Honor.
Good afternoon, Deputy McLeish.
We do have Miss McGehee here. I don't know if you would like to go ahead and visit with her while we wait for Mr. Manning, or wait, but she is here available.
Sure, come on up, Ms. McGee. All right, this is cause number CR 2183, motion to revoke. Ms. McGee, do you intend to hire an attorney? Are you requesting court-appointed lawyer? What's your plan?
Court-appointed, I guess.
Have you filled out the paperwork there at the jail to let us know that you want a court-appointed lawyer?
I didn't know I was supposed to. There was a motion to revoke. Nobody's explained that to me. I had no idea.
Well, a motion to revoke is still, you're still eligible under the Constitution for a court-appointed attorney. So if you want one, you're gonna have to fill out that paperwork so my coordinator can review it and send it on to me so I can make a ruling on it, okay?
I was under the impression that I just have come up here and y'all would say whichever sentence, if you were to reinstate or whatever. I didn't understand it.
Well, that's going to be at a later point. You are still given a Sixth Amendment right to contest allegations against you because the state of Texas has filed a motion alleging that you violated. So you're going to have a chance to contest that. You're going to have a chance to negotiate. And that's when you'll have the opportunity to decide whether or not you want to accept a plea agreement, if the state's wanting to put you back on probation, if they're not. So we need to get an attorney involved in that process. So do you have any financial ability to hire an attorney?
No,
Do you have any assets that you could sell? Home, vehicle, property, jewelry, anything of that nature? Okay, so you need to fill out the application for court-appointed lawyer. And once that is forwarded to me, we'll review it. And if you meet the requirements under the law, then a court-appointed lawyer will be given to you, okay? So what I'm gonna do is I'm gonna reset you for January 5th. That's our next criminal setting. And if you'll get the paperwork filled out, I can get that ruled on quickly. And then hopefully you'll have time to meet with a lawyer if you qualify before then, okay?
I sure will. Thank you.
Your signature right there.
Thank you.
Thank you, Mr. McGee.
Uh-huh.
We might be standing for a while. So. I don't know if you want to share here or just wait till we take the knowledge.
Are you ready, Mr. Manning?
Sorry, yes, Judge.
All right, this is State of Texas versus
Miss Martin, Amber Martin.
Amber Christine Martin, CR 2179, motion to revoke.
Judge, we were really close to having something negotiated today. It has a couple moving parts, and unfortunately, I contacted a incorrect party. So that was my fault. We can reset her from the 26th, but I may be able to get her situation worked out before then. But if we can just have it as a backstop on the 26th, I may be able to get it set for the 5th.
All right, court will set Ms. Martin for contested hearing on January 26th at 1:30.
Thank you.
Judge, I believe that concludes my business. I'd be excused.
Yes, sir, you may be excused. Thank you for your hard work today, sir.
Thank you, Judge.
Judge, do you need anything else from us?
Well, I don't think so. Deputy McLeish. Richard announced on that earlier. So Ms. Heisel, I don't think we set a time for Mr. Augustine. He was the one, or Augustine, he was the one with Mr. Schmidt. We talked about Dallas County not honoring the bench warrant. So I'm just going to put that for status of Dallas County custody on February 7th for Mr. Schmidt.
Sounds good, Judge.
Deputy McLeish, anything else that this court can do for you or your justice center?
No, Your Honor, I believe we have concluded our jail docket. Thank you, sir.
Well, thank you for subbing in and taking care of us out there. We do appreciate you.
Always a pleasure. Thank you, sir.
See you soon.